Welcome back to King and Baver. Yes, hello, Mr. Baver. How are you?
Good afternoon. How are you?
All right. You guys will be happy that Mr. Baver's going to actually chime in and participate in this video lecture, keep you guys laughing, I'm sure, right? So we're back to Prezi and Screencast-O-Matic after our attempt to use Explain Everything didn't go too well, right, Mr. Baver?
You would have been worse.
Could have been worse.
Could have been
What a nice guy. Oh, there we go. So, very good. So let's get started. We're going to talk about the federal court system in video lecture number 3. This will probably be our last video lecture for the federal court system before moving on. So here we go. In this lecture, there are 6 topics. Whoa, Mr. King, that seems like an awful lot to do in a very short time, but let's get started. Judicial philosophy, restraint versus activism. Federal district courts, in particular the lower courts. We'll look at grand juries and court officials. Interesting group of folks, I assure you. Federal courts of appeal and the purpose of those federal courts of appeal and other courts in the federal system. Really? So the question is the federal court system simple? Moving on to topic number 1. Here you go, Mr. Baver. So,
Alright, so the first item on our list of topics involves the judicial philosophy. Judicial philosophy relates to how judges think and reason about the cases they hear.
And remember, a little philosophy never hurts, guys. I know you don't want to hear it, but it's always good for you. It's like eating your peas. Keep it in mind.
Judges can either fall on the side of judicial restraint or on the side of judicial activism. Judicial restraint is the idea that a judge should interpret the Constitution according to the framers' original intention, originalism. A famous law professor and rejected Supreme Court nominee Robert Bork was a creator and proponent of original intention.
This is back in the 1980s under Reagan, a very famous situation where Democrats essentially opposed the Republican President Reagan and his nomination because they feared the Democrats in the Senate feared he was too conservative.
And this movement gained strength or legs in the 1980s under President Reagan and his Attorney General Edwin Meese, as you will read or have read in Tubin. The believers in restraint also typically respected precedent, and they also deferred to the political process to solve many challenging issues.
On the other hand, we have judicial activism. Look at that judge there, wielding that gavel on that poor individual. Crunch, crush.
Boom. Alright, so the concept of judicial activism posits that judges can be flexible and creative in adapting the meaning of the Constitution to meet the needs of the present. The advocates of judicial activism believe that the Constitution was a framework that could and did explain and change as society evolved over time. Historically, activist judges were more liberal, thus we think of Chief Justice Earl Warren and an earlier Warren Burger. More recently, it is the conservative judges who have adopted a more activist stance, or at least in the disguise of original intent. Conservative justices have been reluctant to leave the political process solve thorny problems, affirmative action programs, and issues relating to marriage, and etc.
Okay, so that is judicial philosophy. Now we're going to move on. What do you say, Mr. Baver? How about the federal district courts? Uh-oh. How'd that picture get in there? Mr. King, I don't know how to use Prezi very well, apparently. Well, this is our district attorney for southeastern Pennsylvania. We're going to see him in the next slide. But nonetheless, we're going to talk about 3 layers of federal district courts. There's the district level, the lowest, the appeals court or appellate court level, the second, and then the Supreme Court, the top of the court food chain. So we're going to really take a look right now at the district courts. They're the lowest tier, and these courts really act as the trial courts, and they have jurisdiction. Jurisdiction is a term that means the ability to hear cases for most of the federal cases. These courts are really the bread and butter and the workhorse of the federal court system. This is where most of the judicial work occurs, and there are some 300,000 cases heard each year in 94 federal court districts that exist across the country. And in each of these districts, each of these 94 districts, there are at least 2 judges, though some, for example, the district for Southern New York has a whopping 44 judges. So, what does this mean? More crime in New York City, you say? I think exactly right. Riley, if you've been, what do you think? You ever been to some of these areas in New York City? Creepy, shady characters, criminal activities.
Wouldn't want to be there at night.
Not that Riley would know. Good, clean cut kind of guy. All right. So, what are some of the cases heard before district courts? Well, cases that involve residents of different states, cases involving foreign governments, and cases that involve a number of offenses and/or crimes that Congress has designated via statutes or acts to be federal offenses. So, yes, we're a common law system where judges routinely make rulings that become law, but there are instances when Congress does its job too, though not lately, in passing laws. So there are certain federal offenses deemed such by Congress, such as murder, issuing false statements in trials, tax fraud, insider trading. Insider trading, we all do it, right? I'm not sure about that, but there are about 215,000 civil cases a year and 70,000 criminal cases a year. And I guess we need to talk about criminal versus civil. Criminal is when there's a violation of one of these offenses that is serious, such as murder, tax fraud, insider trading. Criminal cases result in criminal trials, and if you're found guilty, you go to jail. Civil cases involve, moreover, issues like contracts, marriage, and those types of things, and they really regulate how people treat each other in a contractual issue and sense. And civil cases don't lead to jail sentences, they lead to fines. So that's the kind of difference. So I hope that's all clear. We're going to move forward now to
topic number 3.
And there's that guy again, Zane David Meminger. What a name. What a game.
A good name.
I mean, really. Okay.
All right, so topic 3 is the grand jury, which is a panel of citizens called by a district court to hear evidence about a potential case. It is the grand jury's job to recommend to judges if there are grounds for a criminal case.
All right, there we go. And moving on to topic number 4, court officials. Well, these court officials that work for the federal court system include magistrate judges, and they really kind of oversee the early proceedings in trials. So they're like pretrial hearing judges. The U.S. District Attorney, so each of those 94 districts has a district attorney who represents the government side of the cases and presents cases for the government and argues cases, that is, prosecutes cases. So we talk about prosecution, that is the government going after people who have done wrong. In addition to district attorneys, there are assistant DAs, and then we have, last but not least, public defenders, who are those court-appointed lawyers when a defendant cannot hire a lawyer on his or her own. And here in this picture, you really do see Zane David Meminger, district attorney for southeastern PA, which includes Philadelphia and our area. He was appointed by President Barack Obama and confirmed by the Senate. Hello, Mr. Meminger.
All right, so topic 5, we are going to look at the Federal Court of Appeals, and this is the second or middle layer of the federal court system, and there are 13 of these courts, 12 spread across the country and 1 located in Washington, D.C., which has a nationwide jurisdiction to hear certain cases, making the D.C. Court of Appeals special or unique. The courts of appeal are to hear cases on appeals from the district court system. These appellate courts, because they hear appeals, can also hear cases involving the agencies of the federal government. Each year, there are about 65,000 appeals cases heard by the 13 appeals courts. An interesting piece of trivia is that the government cannot appeal a verdict of not guilty, so appeals come from defendants who have been found guilty. The appeals process then is the defendant, known as the appellant.
Big words there, right, Mr. Baber? Those big Latin words. Oh my goodness, stumbling all the time as I do.
In legal terms.
There we go.
So how does this work? Well, the defendant must show or prove that the lower court ruling was in violation of the law or based on a legal mistake. appeals cases do not introduce new evidence or new witnesses. They simply look to see if there was a legal mistake that would lead the court to overturn the verdict.
Now, as you can imagine, if you're ever found guilty, which I hope is not the case, you're always going to appeal your decision rather than go sit in jail and rot away. And so everybody who's found guilty is going to do this appeal process, well, most of the time anyway, and look for some kind of legal mistake. That often doesn't really work, but people have hope, and that's the way we are as human beings. All right, last topic, Mr. Baver. How are we doing on time today? I think we're all right. We got to rush to finish this thing up. Other courts and the Supreme Court. What the heck? Well, you can see there on the screen that there are, in fact, other types of courts that exist in the federal court system. The U.S. Court of International Trade to deal with trade relations and disputes with other nations. The U.S. Tax Court, for those of you that don't pay your taxes on time or evade taxes, you'll hear from the U.S. Tax Court. The U.S. Court for Veterans Claims to deal with Veterans Affairs issues. The U.S. Court of Appeals for the Armed Forces to deal with courts, marshals, and other things. And then this National Security Court system, which really focuses on FISA 1978. FISA is Foreign Intelligence Surveillance Court. So recently we heard of the National Security Administration, the NSA, eavesdropping and spying on American citizens. What do you think, Mr. Baver? Does that make you feel comfortable?
Not really.
You happy to have people reading your text messages? I'm sure they're kind of interesting.
I don't know why they'd want to read my texts.
My text messages are pretty boring and vanilla. Yours, I don't know. But we won't go there. You're protected for the moment. However, the federal government has been spying on its own citizens, and it is the FISA court that provides the authorization. So there are 11 justices. Their names are unknown. We don't know where they meet. We don't know who they are. We don't know what they do, except they can tell the government, go ahead and spy on people, your own people in the United States, which really tends to upset people, especially, I read in a recent poll, millennials from the ages of 18 to 34 are rather ticked off right now at the government and President Obama. So, that is the FISA Court 1978. Better look out for them. They're out there. All right, final word, Supreme Court. It has the final word in our system of the three-layer federal court system. This is where the buck stops, something you should know by now. The rulings of the Supreme Court are final, and they take on the force of law. Unlike Alexander Hamilton, the French visitor and writer Alexis de Tocqueville wrote of the Supreme Court on his 1832 visit, really rather early too, a more imposing judicial power was never constituted by any people. A more imposing judicial power was never constituted by any people. So, do you agree with de Tocqueville? Do you agree that the power of the Supreme Court is final? And de Tocqueville also noted this, that scarcely any political question arises which is not resolved, sooner or later, into a judicial question. So that means that really all the tricky issues and challenging situations that arise in our society, take marriage, for example, become eventually questions that the Supreme Court will invariably resolve. And I think this strongly suggests that the Supreme Court has lots of, you fill in the blanks, let me know. Thanks for being here today with Mr. Baver and I. We look forward to seeing you guys soon.
Thank you.